Okay. Good morning, everyone. This is case number 26 CV-135. Anna Montoya and Charles Wade Thomas, the Robert Douglas Gilliland. If I'm mispronouncing anyone's name, let me know. Oh, do I have to press something? Okay, sorry about that. Oh, all right. So let's just go back on the record. CV-26-135, Anna Montoya and Charles Wade Thomas v. Robert Douglas Gilliland et al. Counsel, announce your presence, please.
Joe Machado on behalf of the plaintiffs, Your Honor, Montoya and Thomas.
All right.
Robert Gilliland, representing myself.
Okay.
Hey, good morning, Judge Allen. Robert May with Santa Cruz County Attorney's Office. Great to see you, sir. It's been a while. And with me is Alma Schultz, who is the elections director.
Okay. All right, this is the time set for the hearing on the election contest that was filed by Ms. Montoya. Are there any preliminary matters anyone wants me to deal with?
Yes, there are, Your Honor. We have some stipulations and the...
Okay.
May I approach?
Yes, you may.
These are the stipulations that we've agreed to.
All right.
And this is the exhibit that we've agreed can be received in evidence.
All right. Being no objection, Exhibit 1 is admitted.
And would the court like me to read the stipulation of the record?
Let me take a real quick look here.
There are some qualifications that are linked to those stipulations as presented by the plaintiffs.
All right. Okay. All right, Mr. Gilliland, and what are your qualifications?
Sure. Just in number 1, it says plaintiffs, it's plural. I know that Ms. Montoya is an elector of the county. I haven't verified whether the other plaintiff is. I can't stipulate that. You said you changed it, though.
Yeah, that's the only one. So the only one that we're dealing with, is Mr. Wade still a party, or are we going to have evidence on that? Or an avowal or whatever?
Well, the stipulation, as far as the both plaintiffs, were that they were residents and electors of this county.
Okay.
But when I presented that to Mr. Gilliland, the other plaintiff was not here, and he would be willing to stipulate that he's an elector and a resident, but he wanted to talk to him first.
I'd like to see an ID.
Well, do you want to take a minute just to chat?
Sure.
And so,
And then that way we can get the stipulation.
all right, why don't you go ahead and do that?
Good.
Nice to meet you. I don't get on the chair. I'm Hamlish, where I have to see you. I can get my act like. Thank you.
I can stipulate to that.
Okay. So, all right, so then go ahead and add Mr. Wade to the stipulation, Mr. Montano, that you're reading into the record, or Mr. Machado, I'm sorry.
If I may, Your Honor, parties have agreed to the following stipulations. Both plaintiffs, Montoya and Thomas, are residents and electors of Santa Cruz County, state of Arizona. Defendant Gilliland is a resident and elector of Santa Cruz County, state of Arizona. Mr. Gilligan seeks the nomination as independent candidate for the office of the Santa Cruz County Superior Court Judge, Division 1 for Santa Cruz County, Arizona. Exhibit 1, which you have marked, are certified copies of the nomination petitions filed by Mr. Gilliland in support of his candidacy. We've stipulated Exhibit 1 may be introduced into evidence. And number 6, in order to be eligible to have his name printed on the ballot as an independent candidate for Division 1 Santa Cruz County Superior Court Judge, Mr. Gilliland requires 386 ballot signatures on the nomination petitions filed by him. And the last point is that should the nomination petitions reflected in Exhibit 1 be declared invalid or void, Mr. Gilliland does not have the minimum number of valid signatures necessary to qualify him as eligible to have his name printed on the ballot as an independent candidate for Santa Cruz County Superior Court Judge, Division 1, Santa Cruz County, Arizona.
All right. Do you agree that that's your stipulation, Mr. Gilliland?
Everything except for in 4, I have other petitions that are not included in Exhibit 1. Those are the petitions made through eQual, the Secretary of State's website. Those signatures by themselves would not qualify me to get on the ballot, so these ones were invalidated. So everything else is fine. I want to make the record clear that as to 4, all of Exhibit 1 petitions were submitted by me, but there are additional ones that were not included in Exhibit 1, which are my equal signatures.
All right. So should we say Defendant Gilliland, filed by Defendant Gilliland with the Santa Cruz County Recorder?
With the elections director of Santa
With the
Cruz
election,
County.
okay.
Maybe right with the physical signatures, because the other ones are also submitted to the county in physical form. It's just they're done through e-qualifying.
How about Exhibit 1 are certified copies of the nomination petitions in physical form, filed by?
We don't indicate number 4 that those are the sole and only petitions filed, only that Exhibit
Okay.
1 are.
Yeah, you don't
Maybe
say,
you just take out the copies of nomination petitions submitted.
All right.
That will work.
That's fine.
okay. All right, so is it all right? I'm going to give this to the clerk, so the clerk will have it for entry. Thank you. Are there any other preliminary matters, stipulations, et cetera? I have a couple of questions I need to ask before we get started. All right, in addition then to the stipulations that were entered on the record, you already covered some of the things that I was going to ask already. Is there an agreement that Mr. Gilliland's residential address appears on each of the nominating positions as the candidate, that his residential address is on the first page of each of the nominating petitions, that is his residential address? Is there an agreement on that?
Well, there's an agreement, Your Honor, that each front page of Exhibit 1 contains information which is allegedly his address. Yes, I don't have a problem with that, and that's not really an issue today.
There's no factual issue that is his address, and that's
Not
same.
for purposes of this argument, no.
Okay, all right. Now, also, Mr. Machado, as part of his answer, Mr. Gilliland has filed a motion to dismiss. I don't know if you want to address that.
Very simple, Your Honor. The statute that he refers to is only in connection with challenges to individual signatures. If we were challenging signatures within a valid petition, then according to that statute, and there's a subsequent statute that requires that they all be identified for the purpose of having the recorder on notice as to which are being challenged. Signatures are being challenged. Which electors are being challenged within the petition itself, and that's for the purpose of not just saying, here's 49 petition, check all the signatures on them to make sure they're valid. The statute is meant to prohibit that type of thing, that type of work for the recorder. It is not applicable, as indicated in our case in Lohr. The challenge in Lohr was, again, not to the individual petitions or signatures within the petition, but to the petition as a whole, and that's what was addressed in Lohr and in our petition for this hearing.
Understood. Mr. Gilliland, is there any record you'd like to make on that?
Yes, Your Honor. The petitioners have filed this challenge under ARS Section 16-351. which is the statute which says in order to file that, you have to put in each line number and page of the signatures that you're challenging. It doesn't say if you're challenging all of them that you can exclude that. It says if you don't include that, the challenge must be dismissed, or the case must be dismissed. We don't have in our record on lore, in that case, what the petition had, and that one very well may have listed out all of the ones for all of the pages that were listed out, the ones that were being challenged. In lore, it's different because he had other signatures from other collectors that also presented them. So I think that they would have had to complete that part of the challenge in order to qualify for it to go forward. We don't have that petition, so we couldn't say that it didn't include page numbers 1 through 49, line numbers 1 through 10. It just wasn't ever an effort to follow what the statute says in filing this challenge.
All right, the court finds that when an entire petition is being challenged, and it is clear that it is the entire petition being challenged, that it's not necessary to list each name on the petition as part of the complaint for a challenge, so it is ordered denying the motion to dismiss.
Can I make additional record for if I take this appeal?
Certainly.
The reason that would still fail is that for my equal petition. We'll go forward. Thank you.
All right, thank you. A couple of other questions that I think that are extremely easy to answer is that there's no dispute that the election complaint was filed timely, correct?
Correct.
And there's no dispute that all parties necessary to the complaint have been joined and served, correct?
Correct.
All right. Mr. Mayor, are you going to assert any position in this issue, in this case?
No, pretty much what you just said, Judge Yelling, is that the petition was filed timely. The election director in particularly accepted the petition. There's very limited amount of categories or situations that the election director can reject the petition. What is being argued in the petition is more of a legal kind of question.
All right, thank you, Mr. May. Does anyone intend to present, we've already admitted Exhibit 1, is anyone intending to present any witnesses or any testimony? I don't think that's necessary, but certainly you're free to do so.
No, Your Honor, that's why we presented the stipulation, to avoid that and to be able to proceed directly to argument.
All right. So, and I guess I'll just start with you, Mr. Machado, and certainly I'll give everyone an opportunity to make a statement, et cetera, but do I read your position or do I understand your position to be that as long as that one line that says circulator's address, if that is not filled out with the circulator's address right there, that is all I need to know about whether or not these petitions are valid? That the words protected address were there, the real address wasn't there, and it doesn't matter whether the address was on the front page.
Well, that's correct, Your Honor. That's the conclusion, yes. That is our position, that our arguments and the reasons set forth in lore, the specific language of the statutes and so on, the reasons for providing the actual address in connection with the purposes set forth in lore and the fact that there's no exceptions provided by statute. So yes, that is the conclusion in a nutshell. Without the address, actual residence address as required by statute, then the whole petition is invalid.
All right. Now, you seem to argue in your memorandum that strict compliance is necessary, but would you not say that lore and the statute itself, and I'm not asking you to admit that they were substantially compliant, but is not substantially compliant the standard that I use?
The lower case doesn't come out and specifically say that strict compliance is the test for that portion of the petition. But if you read the analysis and the reasons set forth in Lohr, and the fact, and that factual basis that an address was provided, and the fact here that there was nothing provided other than quote protected address, they were looking for something more than just substantial compliance. Given the reasons in Lohr, given the statute, the only way you can comply is strict compliance. You provide an actual residence address.
All right. So your argument would be that, and just Mr. Gilliland's argument is that his address does appear on each of these petitions. And that, are you saying that regardless of the standard that I use, that is not substantial compliance?
That is not substantial compliance because, again, if you look at the three distinct and separate parts to a nomination petition, you have the information required by the candidate himself. And it's his name, position sought, and his residence address. Okay? The information required of the elector who signs it is basically the same. Now, as far as those two portions are concerned, there's an exception to having to provide your actual residential address. And that is set in 153, which says if you have the protected address, you can, in lieu of the residential address, you can provide something else. But that something else is a P.O. box and an actual description of what he has.
Sure.
Now, on the third part of the petition, which is the circulator, it's real clear on the form itself, which was established by the Secretary of State pursuant to statute. The form itself is very specific. It has instructions. The statute is specific. It says the circulator must have his actual residential address included in it. And what is important here is that there's no exception to that. There's no exception whatsoever to that. And as the court indicated in Lohr, it starts off its opinion by emphasizing how important it is to comply with the statute and the residency requirements and provide the actual residence address. That's all set forth in the beginning of footnote 2.
But there's no doubt in Lohr that the candidate didn't have her residential address anywhere on the petitions, correct?
That's correct.
And so we don't know if Lohr would have been different if she had put her actual address on there. Because, and I'm sorry to interrupt you, Ms. Machado, but if something's in my head, I got to let it out. Otherwise, it's just going to just, you know what I mean? So when you have a candidate circulating their own petitions, I understand that that person sits in two different roles, candidate and petition circulator. But to a certain extent, the whole notion of a petition circulator implies that it's not going to be the candidate. It's going to be someone other than the candidate. And so don't those functions to a certain extent, if we're talking about substantial compliance, don't those positions to a certain extent merge?
If it was clear that the circulator and the candidate is the same person, then maybe that argument could be made.
Well, how is it not clear in this case?
Well, if you look at the nominations petitions, all of the 49 of them in Exhibit 1, there's a specific address for the candidate in the first part of the nomination petition. The candidate therein is Robert Douglas Gilliland. Okay? The circulator is Robert Gilliland. Okay? The fact that that raises a doubt in and of itself, because if they're the same person, why on earth would Robert Gilliland, the candidate, give his address on the first portion? And if he's the same person that is Robert Gilliland, the circulator, why does he then put protected address if he's the same person? That in and of itself shows that you can't assume that these are the same persons. But moreover, it's not in compliance with the statute. And like in Lohr, the person there provided a post office box. And the court there said, you gotta provide an address because we need to ensure that we can find this guy in the event that we need service of process on him. We gotta ensure that he can be located readily should it be necessary.
Well, we know that because it's on the front page of the petition.
That's assuming that it's clear that the circulator is the candidate. And that's not clear on this record. It's not clear at all. Is he or isn't he? And that requires an investigation. And there's no basis for that. In either in law or statutorily saying, you know, I've given you information sufficient in other parts of the petition. And so, you know what? You do your own investigation. You determine where the circulator is. And that's exactly what Laura was trying to avoid, would not agree with. Now, again, I go back to the point where it can't be strict compliance or compliance, even substantial compliance, by not providing anything. And by saying the protected address, that's not providing any information. If in law, where the candidate provided a post office box, and that was not sufficient, much less is this sufficient.
Well, because you
It
can't,
provides nothing.
you can't serve a post office box.
No.
But you can serve Mr. Gilliland at the address that he provides in his petition.
Again, we go back to the assumption that the candidate is a circulator, and yet can't make that assumption based on this record, number one. Number two, the statute doesn't allow that. The statute doesn't allow any exception whatsoever.
Well, the statute itself says the nomination petition should be substantially in the following form.
Right.
So the statute to me implies substantial compliance is the standard I need to use.
Okay, but again, substantial compliance as to 1 and 2, the requirements of the candidate and the elector are very different, because they're allowed certain information in lieu of the address. And that is not the statutory framework for what is allowed in the, for the circulator. So, Your Honor, the defendant's position is, I've given you this information somewhere on the petition, you figure it out if it's this. If that's the case, then you open up a can of worms on all information or no information required by the circulator or the form of that. If we don't comply with the statute, so well, I've given information, it doesn't matter that I didn't comply with the statute. It's there, figure it out. And that's exactly what Laura said no. If the post office box is not compliant, then certainly it's not compliance here, because much less was provided here than in Laura.
All right, so let me ask Mr. Gilliland a question. And I'm sorry if I'm derailing anyone's plan on how to proceed in this matter. So, Mr. Gilliland, you would agree that protected address in and of itself isn't enough, and that if you had not put your address on the first page, you'd have no argument at all, correct?
My third argument in my answer was the weakest of them. I'm pulling at straws to say, this is where my address is located, because it says in the statute, if no street address given, then a description of the location of the defendant's or the person's residence. I think that there may be room in there to protect judges' addresses. It hasn't been seen, it hasn't been tried further up. I wouldn't go there.
I have a
That's my
feeling,
argument.
and I have a feeling that's addressed to the days when maybe you didn't have an address, or you had a ranch somewhere or something like that, or maybe I think that's addressed to something other than the protected address issue, because that's been in the statute forever.
Right.
So go ahead.
So my argument is much weaker without the one that does comply, not just substantially, but specifically complies with the statute, which says that the circulator's address must be on every petition, and it is on every petition. In the statute itself, it says that the circulator must sign it, and right beneath that, they must write their name. Those are the only ones that seem to be necessary, that they're together and in the same place. Obviously, if I were to do this again to avoid these proceedings, there's no question that I would go ahead and say, you know what, my address is not going to be protected as a judge when I'm going to run for office if I'm going to be a circulator. So in the future, that's where I'm going to be going. But I think that I do qualify under the statute because my address is on every single petition. My name is not Joe Brown, and I know we can't make those kinds of distinctions, but Gilliland is hardly a common name in the city of Nogales, Arizona, which I did include, right? It's not just that I'm somewhere in the county, that I'm in Nogales, Arizona, that's on every petition as well, and it's in the circulator petition spot to say, Robert Gilliland that lives in Nogales, Arizona, it's got to be the same guy as Robert County. And in addition to that, there's no other Robert Gilliland that's going to do all my work for me. I think that it's very clear that I am the candidate circulator.
You raise an interesting point, and I'm not sure I want to go this far, but when I take into account whether or not an elector who is signing the petition could be confused by Robert Douglas Gilliland versus Robert Gilliland, and I'm getting the names right? Yes. Can I take into account something as simple as, quite frankly, a smaller jurisdiction, a much smaller pool of people who would be eligible to run for judge? Are there any other lawyers who have 5 years who have been a lawyer for 5 years named or could be named Robert Gilliland? Now, maybe in a large city that's possible, but in Santa Cruz County? Or does that even matter? Because I think when I have to determine, and I think the language is whether an elector would be confused or misled, can I take into account the circumstances of the jurisdiction in which the petitions are being circulated? Because I have to decide, I mean, Lohr says, citing all the other cases, is there a chance of a person being confused or misled? And Lohr's discussion of that in context of the facts of the Lohr case is kind of, I guess it's not my place to say a disconnect because it's the Supreme Court, but the issue isn't whether the electors were confused or misled. From what I can see, the main issue in the Lohr case was whether or not, if the petition circulator needed to be subject to service of process, we would know where to serve that person. And in Lohr, the candidate put a P.O. box in both places, and that was important to Lohr, the fact that the P.O. box address was in both places and never on the petition itself. So the issue wasn't, and of course the name wasn't an issue in Lohr because the name was the same, but to what extent then can I take into account when determining whether a person would be confused or misled that it is highly unlikely that in Santa Cruz County there would be a person qualified to run for judge who might have the same name but a different middle name than the person who is circulating the petition. So I'll let you deal with that, Mr. Machado, to the extent you think I can even consider that.
You cannot. Your
All right.
Honor, because the test here is the identification of the circulator, not how many people know the judge, and so on and so forth. That's not the test. I know the judge, blah, 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 therefore, it's got to be this guy. I know he's only an attorney. He's an attorney. I know that there's limited number of attorneys there. That's not the test at all. The test is, can I pick up this petition and can I look at it and say, I want to challenge signatures. This is a different type of challenge. I want to challenge signatures. Now, where do I find the circulator? Right? I look at the information. It's not in compliance with the statute. There is no actual residence. Laura says that's the reason that we require an actual residence for the circulator, because we have to ensure that he's readily available, that we can contact him if necessary. That's pretty clear in law. And then what's more important than law, Your Honor, is again, it starts off as its opinion and refers to footnote 2. And it talks specifically about the legal requirements of the necessity of meeting the legal requirements in terms of providing your actual residence address on your as required by law, unless it specifically says, unless the legislature has provided an exception. And in this case, I don't think that's an argument here. The legislature has not provided an exception, has not provided a way to provide something in lieu of the residential address. Then more telling is the conclusion in law. It concludes by giving specific warning to all future candidates. And it specifically says, hey, you are on notice here that in the future, we expect you to comply with these statutes. And if you don't, then you flirt with disqualification. To me, that's a pretty good indication is that we're looking at the statute, people. You need to follow the statute. And in this case, clearly it was not done.
All right. And so, Mr. Gilliland, is there anything else that you want to argue with respect to this?
I would just be reiterating everything that I've already written. I don't know that I need to heavy your ears with that same thing. I think that I have specifically complied with what the statute requires. It's not in the form that petitioners would want it to be. It's not in the place that petitioners would want it to be. And in law, it says, this is a danger that they would be flirting with disqualification, but it doesn't anymore say it means qualification. There's still this substantial compliance test that we're looking at. What I think I'd like to outline, and maybe this isn't the right place for it, because we still have some proceedings, unless we're wrapping up, but we're going to make closing arguments. I would like to say something.
I don't know of any other, yes. To me, I was inviting, I don't know if Mr. Machado has anything else to say. I didn't let people make an opening argument because I went in and asked my questions. So speak now for both sides, and maybe I'll have you, and if you have something different to say than you would say in a closing argument, fine. Otherwise, maybe I should invite Mr. Machado to make his argument, but I think he's kind of already made it.
I think we've touched all our points, and I like this format. I like for the judge to let me know where to go on the arguments or what you're concerned with. So no, I don't have anything additional in terms of my position and in terms of why this is not in compliance with the statute. I just do have one point that I want to bring up that was in the response. Mr. Gilliland in the response says, hey, number one, conduct your investigation. I've given you information, you can do that. We've already touched that. But in addition, he says, hey, you really don't need the circulator's address because 16351, by filing a nomination petition, the elections clerk, director is the agent for service of process, right? That is not relevant herein. That statute applies to the candidate. It says the candidate, by filing his nomination petition, appoints the director as his agent for service of process. There's nothing in there that says that includes the circulator.
Mr. May, do you have a position with respect to that interpretation of the statute?
As far as what Mr. Machado was just talking about?
Yes.
I think that is correct. The agent of service process, and that's probably why the lower case kind of addressed it similarly, is that is as to the petitioner, not necessarily to the circulator. Circulator, in the lower case, they go on to need a way to contact the circulator. So the facts of this case is, well, it is on the petition, the address, and the way to contact the circulator if, as the court had alluded to, they're merged in the document. Lower case is particular, also does not deal with at all the secured address or secured voter. And so it's, while it provides some direction, it's not on point and could be distinguished. So it's a question of how much does the court want to apply the lower case, because the actual secured address issue under, I think, 16153 is not addressed in the lower case at all.
No, because it didn't exist at the time. Okay. Well, 153 then permits the use of a post office box for a protected person. But we don't have that here. It just says protected person. Go ahead, Mr. Machado.
But I get back, even that statutory exception, which allows something in lieu of the action, doesn't apply to the circulator. It does not apply to the circulator. So you can't use that argument that, the statute says I can do it. Statute does not say that.
No, I would say that if all we had was, if a circulator put protected address and the circulator was not the candidate, clearly that would not be enough under 153. I have no problem with that, because you're right. It only applies to the candidate. It doesn't apply to the circulator, which indicates to me, I don't think the legislature overlooked anything. I think the legislature assumed that if a circulator is not the candidate, then there are different rules. But if the circulator is the candidate, then fine.
But Your Honor, that's exactly what's missing from the statute. It doesn't say circulators got to provide this information. Unless you're the candidate and circulator, you don't have to. It doesn't say that.
But would it
And
make
we can't
sense?
assume that.
Would it make sense then to have a statute? Because I can't say the legislature left something out or did something nonsensical if I can avoid it, right? So does it make sense then to have a law that protects people's address who are public officials, et cetera? Could be a sheriff's deputy running, who knows? Does it have a law that says, oh, you can put a post office box in the provision about the candidate, but if you're circulating, you have to put your full address. So,
But that's exactly what the law says. Your
well,
Honor.
that doesn't make sense, because why have protected addresses if you can't protect the address if you're circulating your own petition?
Because according to the footnote lower there's certain constitutional requirements that have to be met, number one. Number two, the candidate is not forced to be a circulator. But if he chooses to be a circulator, he has to comply with the requirements that are set forth in the statute for circulators. But what's important is, and in the footnote, it talks about the legislature providing exceptions. And if it did not provide, then it's a reasonable presumption afterwards or conclusion that it didn't mean to do it. And in this case, it couldn't be clearer. There's 3 parts of the petition. The legislature has specifically allowed you to use a protected address. And it has specifically not allowed that as far as the circulator.
Because maybe the legislature assumed that the candidate and the circulator would be different people, and if they're not, then again, the requirements to a certain extent merge.
Well, Your Honor, what they assumed or what they missed and so on is sure subject to argument, but the fact is, the law as it exists is as it exists. Those exceptions, those in lieu of the residential address requirements don't apply to the circulator. And again, if you want to argue the other way, the legislature says, well, if the candidate wants to be the circulator, then he's got to provide that address. But nothing in the statutes and in Title 16 says that he has to be the circulator. And then there's nothing in there that says, well, if he's a circulator, then he doesn't have to comply with the statute. The statute's pretty clear. And more important, the reasons of law are important. The purpose of requiring that statute is to be able to find the circulator for service of process. That's the key behind all of this.
Well, I agree that that's the law's main concern. Mr. Gilliland?
I feel like we're talking about something other than what's happened in this case, or about other cases that may arise. In the case that we have here, my address is on every petition as required by law. It doesn't say in the law anywhere that it needs to be in a line underneath the circulator's signature. It doesn't say anywhere in the law that it needs to be in a certain place, other than that it's supposed to be on every petition. My plea to the court is on behalf of the voters of Santa Cruz County. As you know, as was mentioned in petitioner's petition here, if I get these signatures knocked out because I was the signature circulator, or the petition circulator on these cases, I don't make it to the ballot. She's the only Democratic petitioner or candidate that's running for office in the primaries. There won't be anybody else that she's opposing. Making that kind of decision today is taking it out of the hands of Santa Cruz County residents. That's all that I want to say.
Well, I mean,
that's not going to take the day.
That's true of every election challenge.
I just want to make sure that's clear. That one of my reasons for fighting so hard to work to get this working is that I have at least 500 people behind me that want this to work.
Okay, all right. It's your complaint, Mr. Machado. So I guess I'll give you the last word here.
Well, Your Honor, I just want to reiterate everything. I think it's clear what our position is.
Okay.
It's looking at the petition, is it sufficient on its face? It's not. It's not incumbent on people to do an investigation. It's not incumbent on people to assume that the circulator is the candidate, especially under these circumstances where the logical question is, well, wait a minute, if it is the same person, then why is his address not protected here and it's protected here? That in itself creates the doubt, the misleading, the confusion that Laura addresses. But more important, everyone's on notice here. We've been on notice since 2020. Do what the statute says and you can be a candidate.
All right. Okay. In preparing for this hearing, I raised in my mind all the arguments that I think I would have made in your respective positions, and you raised the argument that I would have raised. And to me, what is the strongest argument for you, Mr. Chato, is the one you had just said. However, I don't think that in this particular case that there would be, that a reasonable person would be um, misled or confused in this circumstance. So let me make my findings. And one, the court has jurisdiction pursuant to ARS Section 16351A. Two, plaintiffs Anna M. Montoya and Charles Wade have standing to bring this election candidate challenge. Three, plaintiff's complaint was timely and they have properly joined and served all necessary defendants. Four, defendant candidate Robert Douglas Gilliland has answered and appeared. Five, defendant Gilliland has submitted nominating petition as an independent candidate for the office of Superior Court Judge for Santa Cruz County. Six, plaintiffs have challenged the nominating petition submitted by defendant candidate solely on the grounds that all of the petitions submitted failed to provide the actual residential address of the petition circulator as required by ARS Section 16315A4, but instead indicate the petition circulator has a protected address. 7, each of the challenged petitions was circulated by the defendant candidate, and defendant candidate's name appears as the petition circulator on each petition. And I understand there's a question of fact as to that, but that's my finding. 8, each of the challenged petition indicates defendant candidate's actual residential address on the first page of the petition. 9, under relevant case law, a challenge to a candidate's nominating petitions will not be upheld provided the candidate has substantially complied with the requirements of the relevant statutes unless the relevant statute provides for stricter compliance. 10, ARS 16315 does not require strict compliance with its terms, but states that nominating petitions must be in substantially the same form as provided in the statute. 11, relevant case law provides that a nominating petition is in substantial compliance with ARS Section 16315 if the omission of information does not confuse or mislead electors signing the petition. 12, given that defendant candidate's name and actual residential address appears on each of the submitted nominating petitions, no reasonable elector would be confused or misled by defendant candidate's nominating petitions. 13, the present case is distinguishable from Lore v. Bollock, 249 ARIZ period 428, parent 2020, close parent, in that each of the nominating petitions submitted by defendant candidate has information regarding the petition circulator which would ensure that there can be ready and accurate service of process information in the event of a petition challenge. 14, defendant candidates nominating petitions are in substantial compliance with ARS Section 16315. 15, defendant candidate is eligible to have his name printed on the ballot as an independent candidate for Santa Cruz County Superior Court Judge Division 1. Therefore, it is ordered denying plaintiffs the relief sought in their verified complaint and dismissing the verified complaint. It is further ordered that the county defendants include defendant candidate's name on the ballot for the general election to be held on November 3rd, 2026. It's further ordered that all parties bear their costs and attorney's fees. I appreciate everybody's very professional conduct in the court, the well-made arguments, and we'll try to get a written order, a signed written order, as soon as possible for anyone to proceed any further as they want. Thank you very much, and to the clerk, I can give you a copy of the script if you want later. All right. Thank you very much, everyone. You're all excused, and have a good rest of the day.
You guys are difficult.